video needs to be released, and it needs to be released immediately.
Given your extensive experience in police accountability cases, how do you interpret the refusal so far to release the body cam and CCTV footage to the young man's family?
Well, this is an unacceptable delay. Transparency is not optional in relation to these sort of matters, especially where a young life has been lost in police custody. Every day that the footage is withheld compounds the family's grief. But more importantly, in a matter such as this, in the Northern Territory, where there is a 2-month limitation on any action being taken against police. So we're talking about actions related to the potential homicide, so criminal actions, actions taken in relation to potential civil actions, such as the nervous shock claim by the family in relation to the grief and loss and suffering that's caused by the death. The limitation period is only 2 months. In every other state and territory, it's at least 6 years. So in the Northern Territory, to take an action against police, or for police to take action in relation to a homicide, that this may well have been, there's only a 2-month limitation period. So the concern that I have is that the longer the footage takes to find and be aired publicly, the less likely it is that there'll be justice to the family or even to the community.
Family's lawyer and community leaders have drawn comparisons to the George Floyd case. From a legal perspective, what makes such parallels significant or problematic in Australia?
Well, obviously every jurisdiction is unique, but the principles are universal. Excessive use of force in relation to the effecting of an arrest is unlawful. And if there's not a clear understanding of what force was used here, and of course we don't know. Police are investigating police in this instance, and that's a real problem. A real problem in relation to how there might be some sort of understanding of what really happened here. But again, whether or not this was a legitimate use of force and whether or not there was an excessive use of force is a matter that needs in the Northern Territory to be understood within a very specific and confined period of time. 2 months for homicide charges, for any charges to be laid against any police officer. 2 months in relation to any proceedings to be launched against the police or a police officer or the Northern Territory vicariously liable for the police officers in that jurisdiction. So we're looking at a system whereby it looks like someone has asphyxiated this young man. It looks like that. I've seen one photograph, and the knee of a very heavily built police officer, apparently undercover, was on the top of the neck or thereabouts of the deceased. The comparisons to the George Floyd situation are unfortunately riveting.
What civil legal avenues are available to families like this one when a relative dies in custody under such troubling circumstances?
Well, in every death involving police custody, and this is one, there will be a coronial inquest. But that is simply not enough. There are also civil remedies in every other place in the country, except for the Northern Territory, if your claim is not made within 2 months. In every other state and territory, 3 years or 6 years is the minimum period in which you can take action. The Northern Territory is an outlier, and it is a disgraceful outlier because the Northern Territory has the largest Aboriginal population, the largest number of Aboriginal people in custody pro rata, and the largest number of cases where deaths by police are not accounted for in the civil jurisdiction. Because if there's been an unlawful death and the family do not commence within 2 months of the death, then their action is without without any merit and without any possibility of being successful, because the limitation periods are rigorous, they're solidly enforced. There have been cases where homicides by police officers have been lost because they haven't been commenced soon enough. They might well have been lost otherwise, but there have been cases in the Northern Territory because the time in which the proceedings were not started, the cases have been lost.
Officers involved were reportedly plain clothes. How does that complicate the legal assessment of their conduct in restraining a mentally vulnerable person in a public space?
Well, it really doesn't matter if a police officer's in plain clothes or uniformed. It may well have confused a person as to whether they did or didn't have the powers and responsibilities of a police officer at the scene. But the police officer being in plain clothes has no, whether they were on and off duty probably also has no bearing on whether there's any type of criminal or civil liability associated with this. The urgent questions that need to be answered require a release of the material to the family and to the public associated with this death.
Mr. Hargraves, the grandfather, has publicly called for accountability, saying, "We can't keep saying sorry." What role does litigation play in turning apologies into lasting change?
Well, we know from this case, but we've known for a very, very long time, that police officers, investigating police officers, is a failed investigative technique. We need to have a broader level of accountability and a broader level of transparency associated with the manner in which police are investigated, especially where homicides are involved. And this death in custody illustrates very painfully, especially for the family of that young fella, why we need to make sure that police are not investigating themselves, and why those time limits, especially those limits in the Northern Territory, are abolished and expanded as they are in every other part of the country. It shouldn't be 2 months. It should be 6 years, as it is everywhere else in the entire country. Why should Northern Territory Police have the benefit of escaping any sort of liability because they haven't been sued or they haven't been brought to account or charged within 2 months? And that's what the Northern Territory law says. If you haven't charged a police officer within 2 months of the event, the incident giving rise to the death, they are not to be charged. They are not to be held accountable. If you haven't brought a civil suit against the police within 2 months of the event, whether it's a false arrest, whether it's a malicious prosecution, whether it's an assault and battery, whether it's police misconduct because they've beaten someone, if you haven't brought that within 2 months of that incident, you are time barred. And everywhere else in the country, it's 2 years. How is that fair? How is that fair to the people of the Northern Territory, to all in the Northern Territory? But in this case, how is it fair to the family of that 24-year-old kid?
As someone who's seen the toll these incidents take on families and communities, how would you describe the psychological impact of prolonged silence and delay by police authorities?
We need to see the video. We need to see the evidence. The family are entitled to see it. They only have 2 months to commence an action up in the Northern Territory, as opposed to every other place in the country. In the Northern Territory, the family need to know and to see what happened with their own eyes. That video needs to be released, and it needs to be released immediately.